causation. CMR exam tip. For exam purposes, keep in mind that mere pleading, begging, nagging, cajoling, or even threatening do not constitute undue influence. The will of the testator must be destroyed. 9.5.2 Evidence to prove undue influence. Direct evidence. Direct evidence is seldom available because the testator is dead and the person who exerted the influence will lie. Usually, there are no other witnesses to the alleged undue influence. B. Circumstantial evidence. Undue influence is usually proven by circumstantial evidence, which requires showing a number of factors that, when combined, justify the inference of undue influence. Usually one of the factors alone is insufficient to establish undue influence, but different combinations of factors may suffice. Note that none of them, or even all of them, are conclusive that undue influence existed. Although other factors may be taken into account, for example, dispositions at variance with the decedent's stated intentions, unnatural dispositions, in determining whether undue influence caused the result, the court must consider the victim's vulnerability, the ability of the testator to resist, the influencer's apparent authority, the relationship the influencer had to the victim, the actions and tactics of the influencer, for example, controlling the victim's access to necessities or people, use of affection or intimidation, initiating changes to the victim's property or personal rights, and the equity of the result, for example, were close family members cut out without a good reason. Note that the mere opportunity to exert undue influence does not show that undue influence was actually exerted. 9.5.3 Common law rebuttable presumption of undue influence. A presumption of undue influence, which shifts the burden of proof, arises when a confidential relationship existed between the testator and the beneficiary. The beneficiary actively participated in some way in procuring or drafting the will, and the beneficiary unduly benefits from the instrument, that is, provisions of the will appear to be unnatural and favor the person who allegedly exercised the undue influence. A confidential relationship. A confidential relationship includes a relationship between attorney and client, and doctor and patient. Other relationships, in which it is shown that one person relied heavily upon and placed more than a normal amount of confidence in another, such as caretaker and caregiver, may also suffice to show a confidential relationship. See no automatic presumption between spouses or domestic partners. Although spouses or domestic partners are sometimes considered to be in a confidential relationship, no presumption of undue influence arises from a gift to a spouse or domestic partner. B. Procurement of will. To determine whether the beneficiary was active in procuring the will, the following factors are considered. 1. The beneficiary's presence when the testator expressed the desire to make a will. 2. The beneficiaries recommending an attorney to prepare the will. 3. The beneficiaries giving an attorney instructions as to what the will should contain. 4. The beneficiaries' knowledge of the will's contents prior to its execution. 5. The beneficiaries securing witnesses for the will. 6. The beneficiaries being present when the will is executed. And 7. The beneficiaries safeguarding the will after its execution. 9.5.4 Statutory presumption of fraud or undue influence. By statute, California presumes that a donative transfer to certain people is the product of fraud or undue influence, including but not limited to the drafter of the instrument, a person who transcribed the instrument or caused it to be transcribed and who was in a fiduciary relationship with the transferor when the instrument was transcribed, a care custodian of a dependent adult transferor if the instrument was executed during the provision of substantial and ongoing health or social services or within 90 days before or afterwards, a care custodian who commenced a marriage, cohabitation, or domestic partnership with the dependent adult transferor while providing services to the transferor, or within 90 days after those services were last provided, if the transfer occurred, or the instrument was executed, less than 6 months after the marriage, cohabitation, or domestic partnership commenced. Note: people who had a relationship with the decedent before the decedent became dependent and who took no remuneration are not care custodians. A conclusive presumption of fraud or undue influence. The presumption is conclusive with respect to gifts to persons who drafted the will, the drafter's relatives, persons living with the drafter, and persons employed by the drafter. 9.6 Duress. Duress is like undue influence but connotes violent conduct such as the threat of physical harm. 9.7 Fraud. Any gift resulting from fraud is invalid. 9.7.1 Elements of fraud. False representation made to the testator. Knowledge of falsity by the person making the statement. The testator reasonably believed the statement. The false statement caused the testator to execute a will the testator would not have made but for the misrepresentation. 9.7.2 Willful deceit as to instrument or extrinsic facts. Fraud requires that the testator was willfully deceived. For a gift to fail because of fraud, the testator must have in fact been deceived by and acted in reliance on the fraud. 9.7.3 Fraud must be perpetrated by beneficiary. Generally, to effect the will, fraud must be perpetrated by a beneficiary, and only that beneficiary's interest is invalidated. 9.7.4 Types of fraud. A. Fraud in the factum, fraud in the execution. In the case of fraud in the execution, the testator was deceived as to the identity or contents of the instrument, that is, the testator did not know it was a will or what it contained. There was a lack of testamentary intent. Example: Barnabas approached Stevie Wonder, a visually challenged performer, after a concert and asked for an autograph. Although unable to see, Stevie had no difficulty signing what he thought was an autograph book. Instead, Stevie actually signed a will, naming Barnabas as the sole beneficiary of Stevie's huge estate. Because of fraud in the factum and lack of testamentary intent, Stevie's will is invalid. B. Fraud in the inducement. In the case of fraud in the inducement, the testator knows they are executing a will and what it contains, but the testator is deceived as to some extrinsic fact and makes the will or a gift based on that erroneous fact. Example: Father had 2 children, son and daughter. Father's original will divided his estate evenly between his 2 children. Son began a campaign to impugn daughter's reputation by telling father that she used illegal drugs, abused her children, and embezzled money from her employer. Son forged letters and had friends make confirming telephone calls to father to support son's allegations. Son also intercepted letters and telephone calls between father and daughter. Upset at his daughter's evil ways, father changed his will to leave his entire estate to son and then died without ever realizing the truth. The court is likely to set aside father's will because of fraud in the inducement because even though father knew he was executing a will and what it contained, the will was impliedly conditioned on the truth of son's representations. 9.7.5 Fraudulent prevention of will. When a person is fraudulently prevented from making a will, the court may impose a constructive trust on the heirs, even innocent heirs. Some courts will not grant relief. 9.7.6 Remedy for fraud. Tainted portions denied probate. The denial of probate of tainted portions of the will and the imposition of a constructive trust are remedies for fraud. 9.8 Mistake. A mistake is an error that was not caused by evil conduct, no fraud or undue influence, etc. 9.8.1 Mistake in execution of will, mistake in the factum. In the case of mistake in the execution, the testator is in error regarding the identity or contents of the instrument and thus lacks testamentary intent. Extrinsic evidence is admissible to show that the testator was unaware of the nature of the instrument they signed. For example, the testator believed it to be a power of attorney. Such a mistake relates to the issue of whether the testator had the requisite testamentary intent, without which the will would be invalid. Similarly, when the testator mistakenly signs the wrong document, for example, their spouse's will, that document is not admitted to probate because of lack of testamentary intent. Example: testator had several documents on his desk including a letter to his mother and his will. In his haste, he mistakenly signed the will rather than his mom's letter. Assuming these facts could be demonstrated, the will would be invalid. 9.8.2 Mistake in inducement. No relief unless mistake on face of will. In the case of mistake in inducement, the testator is mistaken as to some extrinsic fact and makes their will based on that erroneous fact. Generally, no remedy is available. Courts generally have no right to vary or modify the terms of a will or reform it on the grounds of mistake in the absence of evil conduct. However, there is relief for mistake in the inducement. If both the mistake and the disposition the testator would have made but for the mistake appear on the face of the will. Also, extrinsic evidence is admissible to show that the testator mistakenly believed their child to be dead or was unaware of the birth of the child. Example: father has 2 children, son and daughter. Father's original will divided his estate evenly between his 2 children. Daughter is in the military and is stationed in a dangerous area. In Iraq, the United States government erroneously informed father that daughter was killed during recent hostilities. Father then changed his will to leave everything to son. Father died before finding out daughter was still alive. The court is unlikely to fix this mistake, and thus son would receive father's entire estate. 9.8.3 Mistake as to contents reformation. An unambiguous will may be reformed to conform to the testator's intent if clear and convincing evidence establishes that the will contains a mistake in the testator's expression of intent at the time the will was drafted, and also establishes the testator's actual specific intent at the time the will was drafted. A provision included or omitted by mistake. Extrinsic evidence, including statements of the testator, is admissible to establish both the mistake and the testator's actual intent. The terms of a will are considered together with the extrinsic evidence to determine whether there is clear and convincing evidence of an intent to make, or not to make, a gift, and thus whether reformation of the will is warranted. See disinheritance clauses. Disinheritance clauses are relevant in a reformation action because they shed light on the testator's intent for purposes of determining whether there is a mistake. See rules of construction. Rules of construction are not used in a reformation action if extrinsic evidence is available to supply terms. B. Ambiguities. Contrary to the traditional rule concerning unambiguous language, California admits extrinsic evidence both to establish that a will is ambiguous and to clarify those ambiguities. CMR chartone or more of the requirements for execution is missing. Example: signature missing. Witnesses did not sign in testator's presence. The will has been validly revoked by subsequent instrument, physical act, or operation of law. The testator was under the age of 18 or lacked the mental capacity required at the time of execution. To have capacity, the testator must be able to communicate her wishes and to understand the EECT of the will and its consequences. Influence was exerted on the testator that overpowered the mind and free will of the testator, and resulted in a will that would not have been executed but for the influence. The burden is shifted to the will proponent if the beneficiary was in a confidential relationship with the testator and was active in procuring the will. Either 1. The testator executes a will under a misrepresentation as to the nature or contents of the instrument, fraud in the factum, or 2. The testator is induced into making a will or gift by misrepresentations of fact that influence her motivation. Either 1. The testator was mistaken as to the nature of the instrument, example: thought it was a power of attorney. 2. The testator's mistake in inducement appears on the face of the will, or 3. Clear and convincing evidence establishes the will contains a mistake in the testator's expression of intent and establishes the testator's actual specific intent at the time the will was drafted. Defective execution, valid revocation, lack of testamentary capacity, undue influence, fraud, mistake. GROUNDS for will contest. QLTS prep by BARBRI. Wills, California. 78. 9.9 Remedies for wrongful conduct. 9.9.1 Deny probate. Usually, the evil activity permeates the entire will, and so the entire will is denied probate. However, if only certain provisions are tainted, those can be set aside and the rest of the will probate. 9.9.2 Constructive Trust. If the evil activity prevents a person from executing a will, the court might impose a constructive trust on the property in favor of the intended beneficiary. 9.9.3 Tortious interference with an expectancy. California is one of the states that recognizes this cause of action. To successfully assert a tortious interference claim, the plaintiff must prove that 1. The plaintiff had a reasonable expectation of receiving an interest from the decedent. 2. But for the defendant's interference, the plaintiff would have received the interest. Causation. 3. The defendant had knowledge of plaintiff's expectancy and deliberately interfered with it. 4. The interference was wrongful/tortious in its own right, for example, fraud, undue influence, and 5. The interference damaged the plaintiff. Generally, the conduct must be directed at the decedent, not the plaintiff. Available only if no adequate probate remedy. This tort action is available only if there is no adequate remedy in probate for the interference, for example, a will contest. Thus, this tort remedy usually will be available only to those who lack standing to bring a will contest, that is, those who are not directly interested parties, or when the interference involves a non-probate asset. A no-contest clause in a will does not deprive a party of a probate remedy because the clause is unenforceable if there is probable cause to contest the will. 9.9.4 Wrongful taking or concealment of property. A person who in bad faith wrongfully takes or conceals property belonging to a trust or a decedent's estate, or who takes and disposes of property through the use of undue influence in bad faith or elder abuse, is liable for twice the value of the property and may be liable for reasonable attorneys' fees and costs. These remedies are in addition to those permitted elsewhere, and may have particular application against those who are not beneficiaries or heirs. 9.10 No contest clauses. A no contest clause is a provision in a testamentary instrument that, if enforced, would cause a beneficiary to forfeit their right to take under the protected instrument, that is, the instrument containing the no contest clause or referenced in the no contest clause. The goal is to scare a beneficiary who would get more by INTE Stacy into not contesting for fear of getting nothing if contest fails. 9.10.1 Basic Rule. In California, a court will enforce the provision unless the contestant had probable cause to file the contest. 9.10.2 Full Rule. A no contest clause is strictly construed and may be applied only in the following contests. A direct contest brought without probable cause. A claim that the transferor does not own the property and thus has no right to transfer it, but see below. A creditor's claim, but see below. 9.10.3 Standard no contest clause applies only to direct contests. A direct contest is a contest that alleges the invalidity of a protected instrument, or one or more of its terms, based on 1. Forgery, 2. Lack of due execution, 3. Lack of capacity, 4. Menace, duress, fraud, or undue influence, 5. Revocation of an instrument, or 6. Disqualification of a beneficiary under the interested witness or interested drafter statute. A no contest clause will not be enforced against a direct contestant if there is probable cause to support the contest. 9.10.4 Challenges to transferor's ownership of property, creditor's claims. A no contest clause does not apply to a claim that the transferor has no right to transfer the property or a creditor's claim unless the no contest clause expressly provides for that application. Where the no contest clause so provides, it will be enforced even if there is probable cause to support the claim. 10. Probate and estate administration. 10.1 Probate process. Probate is the process by which the will is judicially established as valid or where the decedent's heirs are judicially determined. The primary place of administration is in the county of the state of domicile at the time of death. If a will is admitted to probate in the domicile, This is generally treated as conclusive in other states for purposes of disposing of personal property. Bona fide purchasers from heirs or beneficiaries are protected if letters of administration or letters testamentary are granted, even though another will is subsequently admitted to probate. In California, another will may be admitted to probate only within 120 days after issuance of the order admitting the first will to probate or determining the decedent to be INTE state, or 60 days after the proponent first obtains knowledge of the will, whichever is later. 10.2 Personal representative. An executor is named in a valid will or codicil. An administrator is a person who administers an INTE state estate or a testate estate but is not named in the will. The spouse or domestic partner and relatives are given priority in appointment. As administrator. In California, one cannot serve as personal representative if 1. Under the age of majority, 2. Incapable of executing the duties of the office, 3. Subject to removal from office for waste, wrongful neglect of the estate, or the like, 4. Not a United States resident, or 5. A surviving business partner of the decedent and an interested person objects to the appointment. The last two provisions do not apply to an executor named in the will. 10.2.1 Powers and duties of personal representative. The primary functions of the personal representative are to 1. Give notice to devises, heirs, and claimants against the estate. 2. Discover and collect the decedent's assets and file an inventory. 3. Manage the assets of the estate during administration. 4. Pay expenses of administration, claims against the estate, and taxes. And 5. Distribute property. Like a trustee, a personal representative serves in a fiduciary capacity. Unlike a trustee, a personal representative is primarily a liquidator and generally must have court approval for such activities as borrowing money, operating a business, or selling property. 10.2.2 Compensation of personal representative. The personal representative is entitled to compensation for their services. If the decedent's will provides for compensation, that will be the full and only compensation, unless the court grants the representative relief from the will provision. If the will fails to provide for compensation, the representative is entitled to statutory compensation based on a percentage of the value of the estate. The court may deny compensation if the personal representative has engaged in dishonest or fraudulent conduct, or has otherwise acted in bad faith or willful neglect of their duties. 10.3 Creditors' claims. The personal representative must give notice of administration to creditors of the estate. Unsecured creditors' claims are barred unless they are filed within the later of 4 months after letters are first issued or 60 days after the date notice of administration is mailed or delivered. 10.3.1 Priority of claims. Claims are generally paid in the following order. Debts owed to the United States or the state of California. Administration expenses. Obligations secured by a mortgage, deed of trust, or other lien. Funeral expenses. Expenses of last illness. Family allowance. Wage claims, and general debts, including judgments not secured by a lien and all other debts.